I hope. Yes, good. All right. So welcome everybody to this webinar that is organized by Central European University and in particular the Legal Studies Department. My name is Maria Jose Schmidt-Kessen. I'm assistant professor at the Legal Studies Department of CEU, and my main focus of research and teaching is competition law and IP law. And I have with me also another colleague from CEU, Karin Lucas, who is also at our department and who got a large research fund to do work on so many. And we have the big pleasure to have with us Bella Kedugiro, who is an advocate of the High Court in Kenya and a doctoral research fellow at the School of Social Sciences and Technology at the Technical University of Munich. And she's also a research fellow at the University of Cambridge and at Sussex University. And her research focuses on competition law, on emerging markets, on the digital economy, and also on gig work and the various angles, of course, also competition law angle on how to regulate gig work. So without further ado, I will give the floor to Bella to start introducing us to the topic of if and how to regulate gig work in emerging markets, and then we'll have some comments and Q&A after Bella's presentation. Thanks so much.
Thank you so much, Maria, for the invitation and accepting to collaborate with the GZ and I on this important subject. So I'm going to give at least a 30 minutes presentation on issues related to the regulation of the gig economy. So in my session plan, I'm going to introduce you to a GZ course on competition in the age of digital platforms and on other legal and regulatory issues that arise from the gig economy that the GZ has done. Then we are going to look at the regulation of gig economy from emerging markets perspective and also look at the role of competition law and employment law in the regulation of the gig economy. And then we look at the way forward. So we start with this GZ course, which Professor Maria will share it in the chat, which is self-placed training program that is made of 8 courses that is targeting policymakers and other key stakeholders in business, in civil society, in government, with the objective of learning smart policy responses in the area of the platform economy, and also to look at the tools and the limits of competition law to regulate the digital labor platform. So why should you enroll for this course? Is because you're going to gain real-world applicable knowledge. We are going to engage with a number of global expertise, leveraging on the insights from leading expertise around the world who are focused on the issue of regulating the gig economy. You're also going to have a number of networking opportunities. And most importantly is that this course is free. And at the end of it, you'll earn certificates. So before looking at the course, let's look at some of the issues that have arisen in the age of digital labor platforms. So the first question we would ask is, what is gig work and what is gig economy? So there's no precise definition of what constitutes gig work, but there's a number of attempts to define what is gig work. So in most cases, when we are defining gig work, this is a labor market ecosystem, but it encompasses temporary and part-time work. And the people that are involved in this labor market are independent contractors or freelancers. And the kind of job they do is for specific pay, and they only perform a specific task. So it's not like a person who's employed by a person who is paid the salary at the end of the month and who is being controlled by the person giving them that specific job. So also, when we look at the digital ecosystem, when it comes to gig work in the digital ecosystem, we have 3 participants. So we have the platform that acts as mediator. So it mediates between the gig worker and the client who needs a specific task to be performed. So the type of gig work we are going to talk about, which other people refer to it as platform work or internet work and so on, is where we have a digital platform that is providing jobs to people through a mediated platform. So we have 2 types of gig work. We have the crowd work, and also we have the work on demand. All of them you request to the internet, but when it comes to crowd work, you perform it remotely, while work on demand, you perform it in a specific location. So platforms such as Upwork, Fiverr, and so on, they form under crowd work. And then those that provide work on demand, we talk about Uber, food delivery platforms, e-commerce, and so on. So gig economy in developing countries is growing with the penetration of the internet, and it's geared towards providing job opportunities and also supporting economic development, as many governments are able to get revenue through taxation. But when you look at the growth of gig work, there's a demand of gig works, especially from low and middle income countries, because in these scenarios, they're able to provide cheap labor. So there's a report that the World Bank has done that focuses on the growth of gig economy in developing countries that clearly states that there's an increasing demand for gig work from developing countries. There's also an increasing growth of homegrown digital platforms in emerging markets that are competing with foreign platforms. So initially, most of the foreign international platforms like Uber and Bolt have their presence in emerging markets, but there's an increasing growth of homegrown digital platforms. And then when you look at emerging markets, when you look at the sectors, ride-hailing, that is in the taxi industry, food delivery platforms, e-commerce, and fintech. These are the sectors that mostly have on-work demand kind of gig work. So the gig economy is providing a number of opportunities, such as creating job opportunities, enhancing economic development, sustainable development as well, because when people get jobs to the internet, they're able to reduce poverty levels. And also with homegrown digital platforms emerging, it's also enhancing the business environment. But there's a number of challenges that gig works in developing countries go through. For example, there's limited regulatory framework, with few countries amending their employment laws or competition law, or even extending labor protection benefits to platform workers or gig workers. And then these gig workers are also working under very poor conditions, such as unstable income, job insecurity, issues related to health insurance as well, and security. And there's limited, and in some cases, no social protection for these workers. And most of them do not engage in the right to collective bargaining. So the question many of us will ask then, why should we regulate the gig economy? And we could say that there's need to ensure fair working conditions from all angles of this regulatory ecosystem. There's need to enhance economic and sustainable development, in addition to promotion of competition within these markets, and also the need to keep pace with technological advancement and development. So the way we look at traditional markets in the absence of internet penetration is not the same way we look at them when now there's internet penetration. So there's a number of regulatory issues and concerns that have arose not only in emerging markets, but also in developed countries. And that is why we are having this kind of conversation. So the first thing that has been very contentious across the globe is the issue of the employment status of gig workers working through digital labor platforms. So in Africa, we had the case in Nigeria, the case of Oladapo, Olatunji, and another, in which they approached the employment court and argued that they were employees. But then the court ruled that they did not fall under the status of who is an employee. So they were recognized as self-employed people. But then the argument is that we have gig workers who are self-employed people, but we also have gig workers who are false self-employed people. These are workers whereby when you look at their working arrangements, you realize that they fall in the same situation as employees. Why? Because they do not enjoy the flexibility that a self-employed person should enjoy when it comes to when they should work, whether they should work, because most of these platforms use algorithms to control when these workers do work. So because of that substantial control that the DLPs are exercising on their workers, then they're more likely to fall under the employee status. And also another important aspect of this is that they're economically dependent on the digital labor platforms. Remember when you were defining what is gig work, it was all about specific pay for specific task. So they're not supposed to have like a full-time salary or so on, or they're supposed to also work with different platforms. If you're a self-employed person, you should enjoy entrepreneurship, independence. And most of these workers do not enjoy it, especially in developing countries where this is their only source of income. And because of the informal sector that characterizes developing countries' markets, we find that some of the workers are employed by the owners of the cars. So there's a different kind of employment relationship. So another regulatory concerns is the issue of the vulnerability of these workers. So if the goal of employment law is to protect the vulnerable employee, we can observe that these gig workers are very vulnerable. They're being exploited by some of the platforms. Therefore, this calls for a regulatory framework or approaches to be adopted by different countries. We also observe, especially from a competition perspective, that the digital labor platform market is highly concentrated, with few platforms that are benefiting from data aggregation, network effects, and the first mover advantage. So these are generally the characteristics of digital markets. So data is very important, and it's a very important input for digital markets because it provides them with an opportunity to ensure customer preferences are taken into consideration. And network effects simply means that the value of a platform increases with specific users being on that platform. So for instance, in the case of the ride-hailing market, you find that drivers want to be on a platform where they're consumers, and consumers want to be in a platform where they can get their rides easily. So a platform that has consumer traffic, a platform that has more workers will have a competitive advantage over other platforms. The first move advantage simply means that the first platform to enter the market has competitive advantage, which is usually accrued from data aggregation and network effects. That is why when we talk about ride hailing, most of the time we'll mention Uber and Bolt. But when you go to specific countries, you'll find that there are homegrown platforms within that market. For instance, in Kenya, we have platforms like Farasi, Maramoja, InDrive that operate in that market. But because consumers knew certain platforms first, you find that they have developed attraction to those platforms and loyalty towards those platforms. So it's very hard for them to move to another platform. So that is some of the regulatory issues. And the South Africa Competition Commission last year did a very critical market inquiry in online platform, intermediary platform market, which found that when it comes to the food delivery platform, Mr. D and Uber Eats are the leading platforms in South Africa. But you find that most drivers, they would want to be on Mr. D and Uber Eats because that is where most consumers and also most restaurants are. So a platform that has gig workers will always have a competitive advantage over other platforms. And because gig workers are critical for the success of any platforms, majority of platforms may engage in a number of anti-competitive conduct in order to attract those gig workers on those specific platforms. And another regulatory issue that we observe within this digital labor platform market is that a number of them are engaging in exclusionary and exploitative anti-competitive conduct, such as predatory pricing, unilateral conduct, price fixing, market allocation, and so on. But then the approach that different competition agencies have taken really differ, and I'm going to look at it in a number of slides that come after this. So the GSA did a market inquiry in 2020, did some research in Rwanda in 2022. And one of the interviews provided this statement. So in this statement, you find that when you read it out and where the interview says monthly payments do arrive, riders are subjected to regular working hours and they're reprimanded to work for a specific platform. So when they're demanded to work exclusively for one delivery platform, this is an anti-competitive conduct. When they're subjected to regular working hours, they're being treated as employees and not self-employed people. When they're being given monthly payments, they are being treated as employees. But then because of the rate of unemployment and underemployment in developing countries, they don't have alternatives. So they take whatever comes. So if you don't want to take it, then you leave. And that is why one of them says, and none felt secure in their working arrangement as they noticed the platform bringing in waves of new riders and threatened to release veterinary riders who demanded employment contracts, more flexibility, and other promised benefits. So because of the experiences of these workers, this becomes an important issue for different countries to look at. So what are some of the regulatory approaches that have been taken? So some countries have taken different approaches. Some have classified certain classes of gig workers as employees, granting them labor rights. Others have used judicial intervention through courts, which have reclassified some gig workers as self-employed. We see this in the UK, in Spain, where in the UK Supreme Court reclassified Uber drivers as employees. In Spain, they reclassified food delivery platform workers as employees. Others have not reclassified them, but they have extended certain labor protection to gig workers. For instance, in China, they have allowed gig workers to unionize and collectively bargain. And others are introducing the employment status presumption. For those in the EU, if you've seen the proposed EU Platform Work Directive, which the discussion is still ongoing, there's an employment status presumption. Of which the platforms are the ones to determine and show that the workers are not employees but self-employed people. In other countries, they have taken a legislative approach, introducing laws, and others introducing regulations. Like in Spain, in 2021, they introduced the Riders Laws legislation, which recognized food delivery workers to be employees under specific circumstances. And in Mexico, they're also considering a law that will classify food and ride-hailing app workers as employees. In Denmark, they have embraced a system where gig workers and platforms can negotiate for better working conditions through collective agreements. In India, in 2020, they introduced the Code on Social Security, extending social security benefits to gig workers, and also established a gig welfare fund. And one of India's states, known as Rajasthan, introduced the Platform-Based Gig Workers Welfare Act, which also extends the right to health insurance and other social benefits to platform workers. Thailand is considering Independent Workers Protection Acts. It's still a draft, while Malaysia introduced the Self-Employment Social Security Scheme designed to cover gig workers and self-employed people. In Africa, no country has considered a legislative approach. This is a very new topic, and that's why we are discussing these issues. But government, especially ministries related to transport and labor, have introduced a number of directives that emerged after a number of public protests against platforms, especially in the ride-hailing market, because the workers were protesting against the high commission rates, service fees, and booking fees that were charged by these platforms. But we are yet to observe any protest from the food delivery or the e-commerce sector, because it's still a new area that many of these countries have not considered. So Tanzania introduced a directive in 2020 by the Land Transport Regulatory Authority that required platforms in the ride-hailing market to reduce their commission up to 15%. And then it also removed the booking fee. But then in this case, Uber and Bolt suspended their services in Tanzania, and they argued that the high commission rate was too high for them to operate in the Tanzanian markets. So they had negotiations with LATRA, and in December 2022, LATRA introduced another commission cap from 15 to 25% and reintroduced the booking fee up to 3%. And the implication of this is that the income that the drivers take reduces as the commission rates increases. But it also shows us some of the unintended consequences, especially from a political perspective. When international platforms operating in emerging markets can just threaten to exit the market. But because they are providing job opportunities, the governments have to rethink their regulatory framework. Nigeria, Ministry of Labor is the first one to recognize a trade union that seeks to pursue the rights of drivers of app-based platforms as a trade union. So the Amalgamated Union of App-based Transporters of Nigeria is now a trade union. So now these kind of workers have the right to collective bargaining agreement, and they have a body that can represent them. In Kenya, in 2022, our government introduced a commission rate capped at 18%. It was very contentious, with some platforms approaching the court to have this commission rate reduced. But now the commission rate is capped at 18%. But what this platform have done is to increase additional fees in the form of booking fees and service fees, increasing what they take from the ride-hailing workers. So these are some of the consequences of regulatory frameworks, especially in developing countries where platforms threaten to leave. And in some cases, some workers have indicated that they're not employees, but self-employed people. They would like to remain as self-employed people, which means that whichever regulatory framework different countries approach, they have to consider whether those workers want to be considered as employees or self-employed people. And also, once we increase the cost of business for platforms, the costs are now transferred to consumers, increasing the consumer price. So we've talked about there's a variation in regulatory approaches approached in different countries because of political consideration and willingness of countries to extend labor protection to gig workers. Also, the level of unemployment and underemployment, the level of digital infrastructure also matters, and the degree of economic and social development. So when we look at gig workers unionization in developing countries, we find that it's very rare, and should have a look at the Leeds Index of Platform Labor Protest by the University of Leeds in the UK. So it's not only in Africa or in India or in Latin America, but in most countries, this kind of collective bargaining agreements are very rare. In Africa, although there's little gig work unionization, we've only mentioned about Nigeria having registered an e-lean app trade union. In other countries, we have informal organizations such as the Ghana Online Drivers Union. Others are using WhatsApp groups to discuss some of the issues they face in this gig economy. So we've seen most of the countries have used employment law to redefine the gig workers as employees to extend labor protection to these gig workers. But then there is another regulatory framework called competition law, for those who don't have a background in competition law, which seeks to enhance the competitiveness of market by ensuring that those firms that are participating in markets have an equal playing field in order to enhance market efficiency and consumer welfare. But under competition law, employees and employers can engage in collective bargaining agreements without having competition liability. Those kind of agreements are not considered as cartel conduct, so that the main objective is to ensure that employees can enjoy better working conditions. But then a self-employed person cannot benefit from this labor exemption because they're considered as undertakings. And if gig workers are defined as self-employed people, then they cannot engage in collective bargaining agreements with digital labor platforms because they will be liable under competition law. And also, it has been observed that most competition agencies have subjected anti-competitive conduct that digital labor platforms engage in to the rule of reason. In this case, they look at the pro-competitive gains that these platforms bring. For example, when Uber and Bolt entered the market, the consumers were able to pay lower prices. So that is a pro-competitive gain. So in case they're investigating the anti-competitive conduct of these platforms have been able to not receive any sanctions or any fining from the platforms because of the gains that come with the emergency of this platform. So it has been recognized that if competition law does not rethink and reassess the application of the labor exemption, then it's going to remain as a barrier to the better working conditions of gig workers. So what is the potential of this competition law? We can extend the labor exemptions to digital labor platform workers, either by legislation or judicial interpretation, but only under certain circumstances. So we have to be very clear under which circumstances can we extend this. Also, we could investigate the anti-competitive conduct engaged by the digital labor platforms by looking at the abuse of economic dependence. Why am I saying this? In most jurisdictions, when Uber was alleged of engaging in predatory pricing, most of the competition agencies looked at the issue of whether these platforms had a dominant position and then look at whether it was abusing that dominant position, which was very, very difficult to prove. So when we look at the abuse of economic dependence, because most of the workers are economically dependent on these platforms, it becomes an important factor to consider and when we are protecting the workers. So I'll just mention what a few competition agencies have done because of time, and also look at some of the emerging markets competition regulation. So Ireland is the first country that amended its Competition Act in 2002, in 2017, and it introduced a new classification of workers, the relevant category of self-employed workers, the full self-employed workers, and the fully dependent self-employed workers. So in Ireland, the full self-employed workers, as earlier mentioned, these are workers that are in the same situation, self-employed people that are in the same situation as employees will benefit from the labor exemption. So they look at all these issues, as I was discussing, the difference between self-employed and employee people. Do they enjoy any independence? Is there control? Is there a relationship of subordination? Do they share the person's commercial risk? So these ones can collectively bargain with those who are giving them jobs. So a fully dependent self-employed person is one that is economically dependent on one person. So their main source of income is not derived from more than two persons. So the Ireland Act does not mention digital platforms, but under Section 4, it gives gig workers working through DLPs the opportunities to apply to the Minister of Business, Enterprise and Innovation to be recognized as people who can engage in collective bargaining. So the first approach we observed is in the EU, and also look at Australia as well. So in the EU, they introduced the guidelines on the application of EU competition law, which is extending the labor exemption to digital labor platform workers and other solo self-employed people to benefit from the labor exemption under competition law. But it has limitation. That's why I was talking about under what circumstances. So it can only apply where those agreements seek to improve the working condition of the platform workers, but not to engage in anti-competitive conduct. So where a platform and a platform meet to discuss the commissions, what to pay the workers, this is an anti-competitive conduct between platforms on horizontal level. So you'd only benefit when it's a collective bargaining agreement between a platform and the worker. So just as Ireland, the issue of economic dependence is considered, the issue of false self-employed people is also considered under the EU guidelines, and digital labor platforms have now been recognized as digital labor platform workers have now been recognized as the beneficiaries of the labor exemption. And because various jurisdictions are reclassifying workers, so if you've been reclassified as an employee, you will benefit from this labor exemption. So what we are talking about is not theoretical, and various competition agencies across the globe are already dealing with these issues. So the first one is the Danish Competition Authority, which argued that a digital labor platform in Denmark known as Helfree could not enter into a collective bargaining agreement with a trade union to provide better wages for its workers who are working as freelancers. So Helfree is a platform that provides cleaning jobs, and it has two types of workers, freelancers and those that have a contract. So they entered into a collective bargaining agreement with a trade union in Denmark, but then the freelancers were also included into that. So what the authority told the platform to do is to change the relationship of its relationship with the freelancer workers. So they changed their contract to employees. So the question is it the best approach that competition agencies should? So in emerging markets, we've not had cases of whether gig workers should have the right to collective bargaining agreement and benefit from the labor exemption. But a number of competition agencies in India, in Kenya, in Egypt, and even in South Africa have had a chance to address competition concerns within the digital labor platform. And one of the main concerns has been the issue of price fixing and predatory pricing. So in India and in South Africa, when Uber was alleged of engaging in predatory pricing, they used the issue of whether Uber had a dominant position, whether it had abused that dominant position for the case of predatory pricing to surface. So because they could not prove the issue of dominant position, then they argued that the competition agencies could not look at the issue of predatory pricing. And that's why we are talking about looking at issues related to economic dependency or the abuse of superior bargaining power. So as I finish this presentation, so we are having employment law, we are also having competition law. There's a need for these two regulatory framework to start looking at the employment status of these workers on a case-by-case basis, because some of them are generally self-employed people, others are for self-employed people. But there's also a need to look at the unintended consequences that arise from the regulatory approaches that we adopt. The issue of ensuring that we are not over-regulating the platform economy, hindering innovation and business investment, but at the same time, we are having a competitive market. So that is the end of my presentation. So I will take you to the course, and I don't know if Maria had shared it. So,
Yes, I have shared it, but I'll do so again. Let me just do that again. For those
okay.
to join. So the course is in the link to the course is in the chat now.
Yeah, and there's also a survey link that
Yes.
you should fill just after the presentation that I've made for us to know whether you benefited from this presentation.
I also posted that.
Okay. So when you click on the link, this is what you see. So this is the courses we're talking about. There are 8 courses. Here we go. So the first course will introduce you to the rise of the gig economy. What do we mean by gig economy? What are the types of gig economy we are talking about? And then the second module looks at the regulatory approaches that different countries have taken. Those that have reclassified the workers as employees, those that have used the courts to redefine the workers, and those that have extended the labor protections to the platform workers. And then module 3 discusses the different types of work, from the normal employee kind of work to informal to non-standard and so on. And then module 4 brings to your attention the working conditions that these workers face. And this is derived from a number of protests across the globe, including low payments, insecurity, lack of health insurance, and so on. Module 5 brings us to data. And I always say that this is a multidisciplinary and a multi-agency regulatory ecosystem. So data protection commissions, labor ministries, competition agencies have to work together and collaborate in addressing issues related to the gig economy. Module 6 is the module I wrote, and this one focuses on competition issues within the digital labor platform market, identifying the competition concerns, the characteristic of these markets that gives them market power. We've talked about data aggregation, network effects, first move advantage, and so on. And also what different countries have done in using competition law when regulating this market. So it mainly focuses on the potential and the limits. And Maria and her colleagues have written a very important paper on how the EU competition law can be used to ensure that gig workers have better working conditions. Module 7, we've talked about the gig economy providing enhancing economic and social development, especially in developing countries, and this is usually done through revenue collection. So to what extent can we tax the gig economy? You learn it in Module 7. And then Module 8, we have to also understand that inclusiveness calls for participation of everybody in the gig economy if you are to benefit from the gig economy. So here we focus on how women can benefit from the gig economy, the challenges that women face when working in the gig economy, because it's very rare to find women participating in ride-hailing upmarket. They are there, but they are very few. How can we encourage them to do so? So that is all about the course. It's free. You can share with everybody, and you can do it at whatever time. And that marks the end of my presentation today.
Thank you so much, Vela, both for the presentation more generally on the regulatory background for the gig economy in emerging markets, but also the course, which is definitely a great way to understand all the layers that you have in the gig economy and the various areas of regulation that could actually bite or that could be used to hopefully make a gig economy market fairer, maybe. So if there are any questions, feel free to post them in the chat. For now, I just want to ask you, Bella, maybe you can share some of your reflections, because actually here in Europe right now, we're seeing the failure of the directive for platform work. So there has been a 2-year project that was supposed to harmonize across all the states in the EU the rules for recognizing platform workers, in particular vulnerable platform workers, as workers. And that would have facilitated them to be, allowed to collectively bargain under competition law. It would have put them in the social security network and so forth. And it was Germany, France, Greece, and Estonia that opposed this. And this being said, France and Germany in particular are known as countries with a high labor protection standard. So it's a bit startling. But we do have a liberal government party in Germany. They were saying, oh, this is, too much burden for platforms and so forth. So what is your take? I mean, even here, there is this balance of we don't want to stifle the development of digital labor platforms too much. And then on the other hand, of course, we want, to provide fair labor conditions. But for example, in Germany, we don't have a reclassification scheme for workers. But one of the largest food delivery platforms, Lieferando, hires all the workers. So all the Lieferando delivery people are employees of the company, and the company has chosen to do so. So there's the argument, the market, will compete for workers, and if there is an interest to give them employment status, the companies will do so to gain a competitive advantage. So maybe just a bit your thoughts on how to draw a healthy balance here, or what's your take?
Yeah, so my take, as I stated earlier, of the unintended consequences of regulating whichever market, not just the gig economy, is that one, we have to consider the politics and power dynamics of this sector. So there are those that are willing to extend the labor protection to platform workers, and there are those that are not willing. And when it comes to developing countries, because most of the platforms that operate in these markets are foreign platforms, even those would operate on location, like the food delivery, the ride-hailing, and so on. And those who operate in crowd work, especially those providing jobs in graphic and design, in research, editing, and so on, are based in the global north. And they're providing job opportunities to people who have no choice, no alternative at all. So they have to take whatever they can take. And emerging markets, governments are trying to create job opportunities for their people. And therefore, they want to create a conducive regulatory framework for these platforms to be able to operate at the domestic level and provide opportunities to their people. So it's part of government policies. But because of the power dynamics, then you find that these platforms have power to influence the regulatory framework at the domestic level. And we always talk about private power influencing the regulatory framework. So what we observed in Tanzania, for a government to come up with a commission cap of 15% in order to protect its workers to get a better pay from these platforms. But then platforms not only threaten to leave the market, but they do leave the market. So when they leave the market, the citizens of that specific country do not have jobs opportunities. They're ready to take anything, even if it's so low, because at least they have something. So they leave the market. So now the governments have to calm down and bow to these platforms and then give them what they want. So as we observe in Europe, especially when I was following the EU directive platform, where Germany and Estonia and other countries are against it. So when you see this scenario, you can think about what will really happen in other countries. So my opinion is that as we move to a proper and appropriate regulatory framework, we'll have to balance the benefits and the costs that are associated with this. And we'll have to consider the power dynamics and the issue related to a conducive business environment for this digital labor platform to thrive. But then we have to tell them that even if you are entering this specific market, you have to ensure that you have better working conditions for your workers. And we've seen some platforms coming up with a number of measures that seek to enhance their workers' rights. In Kenya, we observed Yego entering the market and providing a commission rate of 15%, indicating that they are going to provide insurance, they are going to have a scheme where the drivers can save money and so on. But even when they provide those better working conditions, because of the network effects, the first mover advantage, and platforms that are already in the market and they have the market power in this specific market, it's very hard for these workers to move towards the other platforms that are providing them with better working conditions. So those are some of the dynamics that we are observing in this sector. So there's a need for market inquiries to first understand how these markets are operating.
Yes, that makes a lot of sense. Actually, there is a follow-up question, I think, that connects with what you just said from Karin in the chat. So the question is, which regulatory approaches do you see as most useful? And is there good practice that would apply to any place, or do we need a kind of country-by-country approach to how to regulate the gig economy? And you probably know the European argument, right? Oh my God, don't raise the cost of these platforms so that they need to adapt to every single country they want to operate in, and so forth. So, and you do have a market integration argument, of course, also for the continent. So,
So is there a best approach? I would say that this will be a case-by-case basis, depending on the country's economic development and also depending on the vulnerability of the workers within that economy. So is there a good practice? I would say so far, many countries are trying, even in the US. I don't know if you remember when the New York State came up with a directive of how much Uber gig workers should be paid per hour. And there was a lot of contestation from food delivery platforms and ride-hailing apps about the issue of whether they should be paid per hour. But even when they did that, at least the workers are paid something reasonable in New York. And then you find that there's a variance of how they pay. Even when we focus on the ride-hailing, you realize that most platforms that do not have physical presence in emerging markets. So mostly those are that provide crowd work. The way they pay workers in the global north and global south, there's a big discrepancy on the amount they pay. So there's a need for collaborative framework from different countries and international organizations like International Labour Organization, World Bank, International Monetary Fund, EU. Already, EU is usually a pace setter. So like countries are already looking at the EU guidelines on extent to which our competition law should be extended. So we will have a lot of learning experience, but there's need for competition agencies to also start looking at the competition concerns within this DLP market from a different perspective, because these markets are super different. They're not like the traditional markets whereby you're still using price considerations to determine whether the platforms have a market power or not. So it will really be collaborative, and researchers like us should take the first step to discuss about these issues and let the people know about what is really happening. Because most of us engage with these workers. When you take your ride and the driver asks you to go offline, it's going to affect your security. And that is when consumer protection issues start arising as well.
Absolutely. I think I have one last question that is a bit more specific to the African context. And we briefly discussed earlier, a book that is called The Digital Continent, right? And it provides data. So it's about gig work in 5 different African countries, and very different places, right? So it's the northern countries, sub-Saharan countries. So there's a bit of a comparison back and forth. And one of the statistics that struck me a lot is the informal sector. So you have already a labor market that is not particularly regulated.
Yeah.
And so my question is just, how do you approach, a kind of, or regulating gig work in an environment where your labor market is already, you can see the statistics in some places, 60% is estimated to be informal. So what do you do in that particular situation? I would be very curious to hear your opinion on that.
So in most of the emerging markets, like the formal labor market accounts for only like 20%. So most of it is in the informal market, and most governments have come up with certain rules, even how to tax the informal market. Yeah. So how to now regulate the digital labor market? I would say a number of, let me talk about Africa. African countries have recognized the potential of the digital market. Like in Kenya, we have the Ajira digital platform, and our president has made it clear that the youth should now start looking at the digital ecosystem as a source of job opportunities. In Nigeria, I think they have a Lagos Niger kind of initiative that seeks to provide a conducive environment for the gig platform. And also because the demand of gig workers in most cases comes from developing countries, because, of course, you're going to pay lower wages in this kind of a country. So I think for our governments in emerging markets, even though investment, foreign direct investment of these platforms is very critical to provide job opportunities, it's now time for them to pay attention to the working conditions of these workers. And it's very clear we've had protests in countries that have a digital infrastructure, because we have some countries in Africa that have limited digital infrastructure. You go there, there's nothing like Uber or Bolt or food delivery platforms and so on. The internet penetration is too low. So as the countries focus on enhancing their digital infrastructure, they have to bring on board a number of experts to look at all those regulatory issues that the GLZ looks at. Not only employment, data protection, taxation, participation of vulnerable people, and so on and so on. So in conclusion, I'll say we have to keep monitoring the market, bringing on board experts to discuss a lot of issues pertaining to this market. It's a new area, but the discussion has already started there.
Thank you so much. Thank you so much, Vela. And I don't think there are any further questions in the chat. So I think, first of all, I would invite everybody to have a look at the course because it has really been curated and worked out by experts in the field. And I think there's a lot to learn. Please fill out the survey, right, Vela, which was also about this presentation, right? So it's not just if you take the course. So please take a minute to fill out the survey that is in the chat. And I'll stop the recording here. And thank you so much, Vela, for your presentation. And just a second. So that's